So, friends, welcome to the 289th session of Legal Empowerment through Interaction Lecture Series. It has been a while, but it is indeed wonderful to be back with all of you. It feels like a family get-together yet again. Today, we have wonderful speakers, including Honorable Mr. Justice and Anand Venkatesh, Honorable Mr. Justice P. Gopinath, Honorable Mr. Justice Nyayapathi Vijay, and Honorable Mr. Justice Rajive Bhalla. As far as today's program is concerned, on April 24th, 1973, in a courtroom steeped in silence and charged with burden of eternity, the Supreme Court of India carved a doctrine not found in the text, but etched forever in its soul. The judgment in Keshavananda Bharati was the state of Kerala stands as a constitutional watershed, a moment where judicial restraint yielded to constitutional introspection. The basic structure doctrine evolved therein is not merely a limitation on constituent power, but a principal affirmation that constitutionalism transcends textual finality. On its anniversary, today's program seeks to revisit the doctrine not as a static judicial innovation, but as a dynamic framework that reconciles democratic will with constitutional morality. Through a critical analysis of its jurisprudential foundations, interpretive trajectory, the contemporary relevance, today's program would reflect on how the doctrine has matured into a silent yet assertive sentinel of our constitutional order, ensuring that the edifice of rights, liberties, and institutional balance remains beyond the reach of ephemeral majorities. To give the introductory remarks, we have Advocate K Premraj. Over to you, Prem.
Well, good evening now. Now, it's with the deepest sense of honor that I would address this august audience today, especially to be in the presence of such judicial erudition. It's both a humbling privilege as well as an inspiring experience. Now, permit me to just come directly into the theme of our deliberation. Decoding the silent sentinel of the Constitution, which is the basic structure now. Now, our Constitution, as all of you know, it's not merely a document. It's a living soul of our democracy. It's an indomitable pulse that propels the spirit of our republic. And it's a grand orchestration that tones or that harmonizes the diverse symphony of the country's democratic heart. And it's the moral compass that steers 1.46 billion Indians, casting its radiant glow of justice. Now, encased within the text of Constitution lies more than just the legal scaffolding of our nation. Now, insofar as the Constitution is concerned, that's the embodiment of our collective hopes, of our struggles, and our aspirations, which, of course, we can say it's an untamed will of we, the people of India, who shattered the chains of colonialism and thereafter emerged into the light of sovereignty. Now, at the very core of this monumental edifice stands the idea which is both fragile and formidable. And that is exactly what our basic structure does, which is a judicial creation of unmatched vision that ensures that even while the Constitution bends with the winds of time, that foundational essence, that is the unyielding pillars of our republic, that remains impervious and eternal. And this doctrine guards the very soul of democracy, ensuring that timeless principles of justice, that's of liberty and equality, which of course emerged from the 1789 French Revolution, and upon which our great republic is built, and that endures unbroken across these ages. Now, today's topic has been aptly as a silent sentinel, because the basic structure doctrine that represents a landmark judicial innovation that, as I said, that harmonizes the sovereign will of the people, embodied by the parliament with the timeless principles that define the essence and spirit of the Constitution. Now, the entire revolution revolves around Article 368, which deals with the constitutional amendments. And the core question are, is there any limit to the power to amend the Constitution? Now, this doctrine that emerged in post-independent India as the Parliament's expanding amending powers, that of course it clashed with judiciary's roles of protecting the core constitutional values, particularly the fundamental rights, and the foundational seeds having been sown in Chandri Prasad's seeds, year 1951 Supreme Court 458, where the first constitutional amendment was under challenge. And the Supreme Court held that the power to amend the Constitution was unfettered. And what were the reasons? Because the term law, which we see in Article 13, that did not encompass the amendments made under Article 368, because there was a clear distinction of ordinary legislative power and the constituent power. Then follows 14 years thereafter, Sajjan Singh was the state of Rajasthan, which is AR 1965 Supreme Court 845, which again dealt with Constitution's 17th Amendment Act, which modified Article 31A and even expanding the definition of estate and adding several statutes, 44 to be very precise, into the 9th sheet. Here also Supreme Court goes on to uphold Shankari Prasad. Yes, the Parliament had the unfettered right, the unfettered power to amend the Constitution, including its fundamental rights provision. Now, in this judgment, Justice Hidayatullah and Justice J.R. Mudholkar, they voiced certain concerns regarding the Parliament's unrestricted power over the fundamental rights, even though they had upheld the 17th Amendment. I will come to that in a short while. Then we had the famous 11-judge bench in Golakna was the state of Punjab. It is AR 1967 Supreme Court 1643, which fundamentally again questioned the validity of the 17th Amendment. And this judgment, it altered the power dynamics. By a fractured majority of 6-5, Shankari Prasad and Sajjan Singh got overruled, holding that the Parliament under Article 368 could not amend or alter the fundamental rights, holding that Part 3 that occupies a very paramount position, safeguarding the essential rights which are crucial for the development of human personality. And the constitutional amendments, it were deemed to be law. It was a legislative process subject to either ordinary or special majority. And that from 27-67, which was the date of the judgment, 27th of February 1967, Parliament would no longer have the power to amend any provision of Part 3. Now, this was the first instance where we see the doctrine of prospective overruling that was being introduced in our country. And the apex court, of course, found that the first, 4th, and 17th constitutional amendments, they had curtailed the fundamental rights, even though it upheld the validity by the doctrine of prospective overruling. And today, as we commemorate the 52nd anniversary of the landmark 13-judge bench in Keshavananda Bharat, that is AR 1973 Supreme Court 1461. Now we pay tribute to a very defining moment in India's constitutional odyssey. Again, this was a very slender 76 majority. The Supreme Court goes on to etch into the jurisprudential legacy that the monumental basic structure doctrine, a doctrine that has since stood as the inviolable sentinel of our constitutional integrity. And it is in this historic pronouncement the upper court goes on to overrule Golakna, and it upheld the Parliament's plenary power to amend the Constitution. But of course, it drew an unbreachable line that no amendment, however far-reaching, you cannot dismantle or you cannot efface the Constitution. And this has been the timeless soul of our democratic defiance. Now, the words used were not dismantle or efface, because it was damage, emasculate, abrogate, abridge, change, alter, several words. And this Keshavananda Bharati judgment, that is the bedrock of our constitutional resilience. And as we see, the framers of our constitution in their deliberations in the Constituent Assembly, they had drawn no express distinction between the essential and non-essential features in our constitution. And nowhere in this extensive Constituent Assembly debates we can encounter the term basic structure. Then where did this term come from? In Sajjan Singh, as I already mentioned, Justice Mudholkar, in a moment of remarkable foresight, he posed a question of enduring significance, whether the basic features of the Constitution, which we live and to which we owe allegiance, are to endure for all the time, or at least for the foreseeable future, or whether they are no more enduring than the implemented and subordinate provisions of the Constitution. Now, it was he who used the term basic feature that you can see 5 or 6 times in the judgment and points out that this term has found its first judicial articulation, not in India. That judgment, Justice Golkar refers to another judgment of the Supreme Court of Pakistan, that is Fazlul Qadir Chowdhury versus Muhammad Abdul Haq. It is 63 decision of the Pakistan Supreme Court, where the then Anglo-Indian Roman Catholic Chief Justice Alvin Robert Cornelius of the Pakistan Supreme Court, he employed this term while reflecting on constitutional permanence. And of course, in the modern times, it's an irony that while Pakistan is a country which at first articulated this enduring constitutional phrase, in practice, it falls short of safeguarding the fundamental rights of its own people. Now, in Keshavananda Bharati, we can see the great jurist Nani Palkiwala. He drew upon the influential work of the German scholar, Professor Dietrich Conrad, and his article on limitation of amendment procedure and the constitutional power, in which Professor Conrad, he referenced the West German provincial constitution, which explicitly excluded the fundamental rights from the scope of constitutional amendments. In 1973, the basic structure doctrine, as we all know, it had no foundation at all in the judicial precedent or the court rulings. That's what exactly Shyam said. In February 1965, while addressing a law department at Benares Hindu University on the implied limitations of the amending powers of the Constitution, Professor Conrad, he posed a series of thought-provoking questions. He noted that India had not yet encountered an extreme constitutional amendment, and he urged the jurists to remain vigilant. Unrestricted parliamentary power with caution could lead to profound consequences once that the democracy must be prepared to confront with constitutional wisdom and, of course, with caution. And he challenged the audience with certain incisive hypotheticals. To quote a few, could the parliament, for instance, amend Article 1 and divide India into two separate nations? Could you erase Article 21 and with it the fundamental right to life? Or could it, by an amendment, dismantle the whole constitution and reinstate the monarchical rule, be it either under the Mughal Emperor or the British Crown? Now, as you see, these were not mere academic musings. They struck at the core of the constitutional integrity, emphasizing the necessity of a durable framework of our foundation principle. And his insights ultimately laid the intellectual foundation for one of the most significant documents in the Indian constitutional jurisprudence, which we see in the basic structure document. And amidst this four judgments which I have cited, I will just say there are two must-read judgments on basic structure document, which is one is I.R. Polo, the 9 judges bench, 2007, 2 SCC page 1, and the other is the Janhid Abhiyan case, which is recent judgment, 2023, 5 SCC page 1. That again is a constitutional 5 judges. Well, I believe that I may have exceeded my time for the topic intro. So just permit me to conclude with a thought that needs no more elaborate introduction. Now, the basic structure doctrine that has long since transcended the need for a detailed exposition. And as we know, this there exists no exhaustive catalog or no definitive list as to what constitutes basic structure. And over the course of India's constitutional journey, our judiciary, through recent interpretations, and they have steadily eliminated the contours of this doctrine, not to restrict the democracy, but to refine and preserve its integrity. And today, this doctrine, it serves as a constitutional sentinel, a moral and legal firewall against the excesses of transient political power. And of course, I would like to say one word about this Keshavananda Bharati judgment, which is in a separate dissenting judgment in Minerva Mills case, which followed 1980. Justice Bhagavati, he said that the finding, the ratio in this Keshavananda Bharati case, that was a difficult and troublesome question. We are not concerned. Now, coming to the distinguished speakers of the day, we are honored to be in the presence of 4 towering stalwarts of the Indian judiciary, eminent judges whose brilliance, integrity, and unyielding commitment to constitutional values have not only enriched our jurisprudence, but also helped to shape the very soul of our legal discourse. And each one of them, they have etched his own name among the most revered judges of our times, the lodestars in the constellation of Indian constitutional thought, and they steadfast as the guardians of the soul of our republic. Now it's my honor to first welcome Justice Anand Venkatesh of the Madras High Court, whose very name has become emblematic of fearless adjudication and a progressive constitutional conscience. Through judgments that are as bold in their vision and as humane in their essence, His Lordship has not merely interpreted the Constitution, he has virtually illuminated, breathing life into its promise of dignity, liberty, and moral integrity. And his decisions ringing with clarity and intellectual depth, they transcend the confines of the courtroom to stir the conscience of a nation yearning for justice. And beyond the bench, his eloquent writings in leading newspapers, they reflect a rare ability to distill complex societal challenges into reflections both profound and provocative, marking him not only as a guardian of law, but a voice of our collective moral imagination. Equally, it's our distinct honor to welcome Justice Gopinath of the Kerala High Court, a judge whose works exemplify the rare confluence of analytical precision and empathetic depth. With a keen intellect, finely attuned to the complexities of economic jurisprudence, and a steady hand guided by the enduring principles of constitutional law, His Lordship crafts his judgments that are as lucid in reasoning as they are very weighty in their clarity. And in every pronouncement, there reposes a balance of mind and spirit, a judicial philosophy that blends with logic, with humanity, and of course, rigor with restraint. And his decisions have not only shaped the contours of contemporary legal thought, but have also earned him deep respect across both the legal fraternity and the broader citizenry. Then we are deeply privileged to have the presence of Justice Vijay of the Andhra Pradesh High Court, who according to me is a towering intellect and a steadfast sentinel of constitutionality, whose every word from the bench carries the weight of moral authority and the clarity of judicial purpose. And His Lordship's jurisprudence that transcends the bounds of legal craftsmanship, the sublime fusion of erudition, moral rectitude, and a deep, almost sacred allegiance to the idols of democracy. And each of his judgments rises like timeless edifice, etched into the bedrock of constitutional fidelity and polished by the brilliance of reason, and radiant with unflinching devotion to justice's highest calling. And I have to say that Justice Vijay's court is a sanctuary where the Constitution literally breathes, not as a static document, but as a living covenant with the people. And finally, it's our distinct privilege to welcome Justice Rajive, Bhalla, formerly of the Punjab and Haryana High Court, and now a well-respected senior advocate before the Honorable Supreme Court of Punjab. And His Lordship embodies a rare and seamless continuum. From an eminent tenure on the bench to a commanding presence at the bar, he bridges the two pillars of the legal realm with his unmatched grace and professional distinction, but of enduring influence, which is marked by intellectual luminosity with forensic finesse, and of course, the wisdom that resonates in both judgment and advocacy. And in studying the dual words of adjudication and argument, he stands as a singular figure who is a mentor to many, exemplar to all, and a living testament to the enduring dialogue between last reason and last spirit. And together, these four legal luminaries, they represent the finest traditions of Indian constitutionality. They are courageous in thought, they are meticulous in reasoning, and they are steadfast in their commitment to justice. And today, we are in the presence of sheer brilliance, and we await with great anticipation the insights they will share, the insights that will undoubtedly guide, challenge, and inspire us long after even this session concludes. Thank you all for your patient listening.
Thank you, Prem. That was just wonderful. And without wasting any time, we are anxious to hear the words of and share the thoughts of Justice Anand Venkatesh, sir. Over to you. Sir, you let to unmute, sir.
Yes. Good evening, Shyam. Good evening, Prem. Thank you for your kind words. Good evening, Justice Gopinath, Justice Vijay, Justice Rajive Bhalla, now who is a senior advocate in Delhi High Court, in the Supreme Court, sorry. It's very nostalgic. It's like homecoming for me. This is something which we used to do regularly in 20 and 21 when we were in the grips of the pandemic. Anyway, thank you so much for inviting me. Thank you so much for all those who have managed to make time to participate in this. So what I'll do is that I'll quickly lay down some foundations so that the other three eminent speakers can build upon that easily. So that's what I'll attempt. To start, I must say that there are a lot of rumblings nowadays saying, is it a judicial overreach? Did the Supreme Court outweigh the will of the Parliament, which has representatives who represent the will of the people? And was it a judicial overreach, or is it a constitutional necessity? These are certain questions which are being discussed at all levels. I propose to deal with this under four heads broadly. First is what led to the basic structure doctrine in Kesavananda Bharati. Most of it which was covered by Prem, so I would quickly recap what he said. Second is, what does this basic structure mean? Meaning, what does it constitute of? That's something which we are trying to understand. Then what was its role after it came into being, and how is it applied, is the third head. And the last one would be the rumblings. Is it a judicial overreach? And does it require a revisit? So broadly, these are the four heads which I'll quickly try to cover in 10 to 15 minutes maximum, if that is fine with you. So first is what led to the basic structure. What led to the basic structure is, as you all know, right from the beginning, the Congress government was promising major agrarian reforms. And various land reforms act were passed in many states across India. Many high courts started striking it down. So it was, the government thought that the agrarian reform sought to be brought in is being threatened by the courts. And that's how the First Amendment came. So two articles were proposed to be passed, which are 31A and 31B, as all of you must be knowing. What is more important is that one brilliant, sharp brain from Madras was behind it, and he was then the Advocate General of the Madras High Court. His name is V.K. Thiruvenkatachari. So he was the one who came up with this Schedule 9. 9th schedule was his baby. It was his introduction. So therefore, that contribution actually came from here. So 31A, as you all know, it's to ensure that the agrarian reforms will pass muster, notwithstanding that it violated Part 3. And this was also given a retrospective effect. From the coming into force of the Constitution. And then 31B stated that any act, that's the most important word. It did not just stop with including, it included Land Reforms Act, but it said any act that is put into the 9th schedule, it will be insulated from any challenge. And it was wide enough to the extent that even those laws which were struck down by the Supreme Court, which was struck down by the High Court, would revive if it is put back to the 9th schedule. So thus came the First Amendment, as I said, it's Act 1951. I would say that the First Amendment is very unique because the Constitution itself enabled some parts of the constitution unchallengeable. It's a very unique thing which came into being by the First Amendment. Then, as you know, let's fast forward to 15 years. 15 years, 17th Amendment came. In 15 years, 17 amendments were made. And the 17th Amendment inserted nearly 43 land reforms laws into the 9th schedule. So by then there were nearly 64 entries, which included land reforms laws and other acts also. So, and as Prem was saying, till then the judgment in Shankari Prasad was ruling the field. And as he said, this Patanjali Shastri who had penned that judgment, the fifth issue in that judgment, this is for the benefit of juniors who must be listening to this. Whenever I mention some, because I cannot go deep into all these things with the limited time. So the fifth issue is very important for the topic which we are discussing today. It was held that the answer for that fifth issue was that the harmonious construction of Article 13 and Article 368 would lead to the conclusion that in the context of Article 13, law must be taken to exclude constitutional amendments effected under Article 368. Thus, the power of the Parliament to amend the Constitution was held to be absolute, untrammeled. This is what comes out of Shankari Prasad. So, as I said, the 17th Amendment came and 17th Amendment was put to challenge. That was put to challenge, as Prem was saying, in Sajjan Singh case. Sajjan Singh case is in 1965. Sajjan Singh case was penned by Gajendra Gadkar, Chief Justice Gajendra Gadkar. He delivered the judgment. And in fact, even before I touch Justice Hidayatullah and Justice Mudolkar, the last paragraph of Gajendra Gadkar itself is very important in that judgment. If you look at paragraph number 36 in that judgment, 36 of the judgment in Sajjan Singh, Gajendra Gadkar would have given a suggestion that Part 3 kindly include it in the proviso to Article 368. So he would have said that instead of Part 3 getting knocked off with a majority in the Parliament, try to get the ratification of half of the states, like how it is done for others, so that it will be more difficult to get the amendment done. So that is one suggestion which Justice Gajendra Gadkar had given. Many missed that. The last 36th paragraph, this is what he says. This is a suggestion which he puts. And from there, two brains originally think, which is, one is Justice Hidayatullah and the other is Justice Mudolkar. Justice Hidayatullah points out to the anomaly in the amendment that can be done to Article 226 and Article 32. So Hidayatullah says that if you want to knock off Article 32, it's enough for you to have a 2/3 majority in the Parliament. But if you want to knock off a 226, apart from the 2/3 majority, you must also have the ratification of the states. So he uses a very, very interesting term in paragraph 47 of the judgment. He says, Part 3 of the Constitution cannot be a plaything. He uses the word, it cannot be a plaything of a special majority of the Parliament. So that's the expression which he uses, and it's a very important expression of Justice Hidayatullah. The judgment of Mudolkar, I would earnestly request the juniors, request the members to read that portion of Justice Mudolkar. Justice Mudolkar, for the first time, makes a very thought-provoking observation that a time has come where Shankari Prasad requires reconsideration. Before I go into that, I must tell you that it's a unanimous decision. They have followed Shankari Prasad and they are upholding the 17th Amendment. But the spark comes from the judgments of the concurring judgments of Hidayatullah and Mudolkar. So Mudolkar, he makes it's a paradox, as Prem was saying. Mudolkar refers to the Pakistan Supreme Court. So Pakistan Supreme Court was it is in 1962, what happened was an article was inserted, which is Article 244 of the Constitution, and it enabled the president to make amendments to the Constitution to remove difficulties. And it said that if such amendment is made, it cannot be subjected to judicial review. So that's the long and short of that amendment which was brought in. This was challenged, and this judgment was penned by Justice Cornwallis, Chief Justice, and he talks about certain essential features which cannot be taken away. So Justice Mudolkar takes a cue from that observation made by Chief Justice Cornwallis. Then Mudolkar, as Prem was saying, uses this term essential features at least in 5-6 places in that concurring judgment. And he says, if you look at paragraph number 61, he says, if you take away everything, you take away 14, you take away 19, you take away 21, he says, will a constitution be there? Is it a constitution? He asks the reader that question. Is it a constitution? Will this constitution remain there? Then Mudolkar also tries to find out what those essential features are. So that you will find at paragraph number 62 of that judgment. Just keep writing those paragraphs so that you will find time to read it, because what I find is that many don't read this at all. Many read commentaries and start talking about it. So it's important to go to those paragraphs and read. Only then you will get the soul of what those judges were trying to tell us. So he says, what are those essential features? Where do I get it? So there what he does is he lays his hand on the preamble of the Constitution. He says here it gives certain things as the basic structure. So this is the spark that comes from Mudolkar and Justice Hidayatullah, and that spark works in Golaknath. As Mr. Prem said, it worked in Golaknath, 9-member bench. Again, it's a wafer thing majority, 6-5 in Golaknath. And they held that Article 368 only deals with procedure. That's an important word there. Deals with procedure. And the power to amend the Constitution is derived from 245, 246, 248, etc. So they said ultimately that a constitutional amendment is also a law within the meaning of Article 13 of the Constitution. And if it takes away or abridges the rights conferred under Part 3, it is void. The long and short of it is that. So, as Prem said, the Supreme Court applies the concept of prospective overruling there. Thereby, the amendments that were made till then were all saved by the Supreme Court. Then, as you know, the bank nationalization judgment came in 70. Then the Privy Purses came in 71. Then comes the 24th, 25th, and 29th Amendment. This is the bedrock now. So the 24th and 25th Amendments were actually inserted with the aim to somehow outweigh Golaknath case. That was the purpose for bringing in 24 and 25. So broadly, 24th Amendment inserted Article 13(4), subclause 4, and said that nothing in this article will apply to any amendment carried out under Article 368. 25th Amendment introduced Article 31C, and basically it said that no law that gives effect to the policy of the state towards the directive principles of the state policy under 39B, 39C shall be deemed to be void on the ground that it is inconsistent or takes away the rights conferred under 14, 19 or 31 of the Constitution. And it cannot be called into question in any court. Broadly, I'm not getting into too much of technicalities into that. This is broadly what it said. Then the 29th Amendment was the one which inserted 2 Kerala land reforms laws into the 9th schedule. In comes Holiness Sri Kesavananda Bharati. That's how he gets into the picture. And on a lighter side, all the 68 days when this case was happening, every day evening during the news the radio, whenever they used to read the news, Kesavananda's name used to come on a daily basis. So His Holiness Kesavananda seems to have asked the others as to what wrong did I do? Why is it that on a daily basis they are uttering my name on a daily basis? So he was really shocked and he didn't know why his name is being said on a daily basis. So the reason is simple. The reason is that that was the lead case. Since that was the lead case, it was called as His Holiness Kesavananda Bharati. So the 24th, 25th, 29th amendments were challenged. Many think that Kesavananda Bharati case virtually wiped off everything. It is a wrong impression. Actually, most of it was in favor of the government, because 24th amendment was upheld, 29th amendment was upheld, 25th amendment, the second part alone was held to be against on the ground of this basic structure doctrine. So it's not a case where many are assuming, since they don't read Kesavananda Bharati, many assume that entirely it all went in favor of, nothing went in favor of anybody. 24th was completely upheld, 29th was completely upheld. The second part of 25th alone was struck down on a very wafer thin majority. So this is how the Kesavananda Bharati came into being. So the second one which I thought was, what does this basic structure mean? What does it mean? As I said, while dealing with the second issue, first is the spark from Justice Mudolkar. Justice Mudolkar gave an indication even in Sajjan Singh case, as I told you. So he was pointing out to the preamble of the Constitution. If you go through the Kesavananda judgment, you will find in the judgment of Justice Ray at paragraph number 876, he would have listed the 12 things which Justice Palkiwala had argued as basic structure. So there will be 12 heads which you would have noted. That's the only paragraph you will get the entire 12 things which Palkiwala was trying to structure as a basic structure. So that's where you will get. The other place where you will get is the judgment in the Indira Gandhi case. Justice Chandrachud, who was one of the minority, whose judgment was one of the minority judgment in Kesavananda Bharati, completely accepts Kesavananda Bharati and writes it in Indira Gandhi, where he sets out 4 or 5 essential features which can be considered to be the basic structure. Here what is important is that we have to recall Justice Khanna at this moment. The most important part of the judgment is understanding this basic structure was the one penned by Justice Khanna. Please go through paragraphs 1426 to 1430, 1426 to 1430 in the judgment. I would say paragraph number 1426 was the one which tilted the whole thing. So it's not a judgment of 7:6. I completely concur with Senior Advocate Arvind Dattar that it is 6.6 to 6.4. It is that way for thin. If you remove paragraphs 1426 to 1430, it's finished. It would have gone that way. It's that way for thin majority in that judgment. And one thing which I have to say here is that if you look at one of the paragraphs in that judgment, the Justice Khanna, like a codicil to the will, what Justice Khanna would have done is that he would have clarified what he had said in Kesavananda Bharati's case in Indira Gandhi case. So if you look at paragraph number 1508 in Kesavananda Bharati's case, Justice Khanna would have said that that fundamental rights as a whole can also be a subject matter of the amendment. He would give such an impression in that particular paragraph, in paragraph number 1508. So in Indira Gandhi, he knew that many were talking about it. So I always say that it's a codicil to the will. So what he will do is, In Indira Gandhi case, he will say, nowhere in the judgment did I say that the fundamental rights as a whole are not part of basic structure in the constitution. What I said is that right to property is not a part of basic structure. You will find that at paragraph number 252 and 253 in the judgment in Indira Gandhi case. So why I said this is that if you look at the EWS judgment, the quota case, EWS quota case about which Mr. Premraj was referring, 23, you will find one portion of Justice Pardiwala where Justice Pardiwala would have taken note of the observation made by Justice Khanna in Kesavananda Bharati, and he would have commented that the view of Khanna was very different from the other 6 judges when it came to part 3. But actually that was explained subsequently by Justice Khanna in Indira Gandhi case. So that was, so therefore many had a view that actually Khanna never meant that. But Khanna corrected himself, or rather explained himself. He got an opportunity to explain himself in Indira Gandhi case. So that's a very important thing which I thought I should point out. So the one more thing which I want to point out is Palkiwala himself wrote an article about this. After the arguments, after the judgment, etc., Palkiwala himself wrote an article which is called as a fundamental rights case. He explains that implication of the judgment, which also gives you a good idea as to what this basic structure is. So from there, I'll move to the third one, which is what was its role? What was its role? How was it applied? It's very interesting that because of a basic structure doctrine, a constitutional amendment can become unconstitutional. Just recall what I said in the beginning. I said that the First Amendment is very unique because Constitution itself enabled some parts of the Constitution unchallengeable. But here, because of the basic structure, the doctrine made the constitutional amendment itself unconstitutional. It's a very, very interesting thing which happened. So what is the jurisprudential justification for this basic structure? Because basic structure is something which never had a precedent. Because when you read the books by Arvind Dattar, Andhyarjuna, you will find that Palkiwala never had a precedent to really quote before the court. What the precedence he had was the procedure that is adopted, and then once the procedure is not followed, what happens to that amendment? He never had this. So we'll have to look at, is there a jurisprudential justification for this basic structure? There are some literature available from Israel, from South Africa, where they employ this principle called as principle and agent principle. So what they say is that in a written constitution, basically, the legislature, the executive and judiciary have been delegated with certain powers. So they are called as the agents under the constitution. And like a general principle where an agent cannot go against the principle or he cannot act against the interest of a principle, the agents, namely the legislature, judiciary and executive, cannot act against the mother document called as the constitution. So that's how there is a jurisprudential justification for basic structure also. So as I said, the going forward, what role it played? What role it played is that it was applied in some very, very important judgments thereafter. It was applied in the case of the 32nd Amendment, which is the Sambamurthy case, Article 371D. Then it was applied during the 39th Amendment, Indira Gandhi case. Then it was applied during the 40th Amendment, where inserting certain laws into Schedule 9. Then Bhim Singh Ji case, that is in 1985. Then the 42nd, the most draconian of the amendments which was attempted. And as you all know, it was dealt with in Minerva Mills case. Then Quixote-Holguin case, which was in 1992. So basically, it took away judicial review from the ambit of anti-defection law. Then the 44th Amendment, which brought in Article 359, actually recognized basic structure. Parliament itself recognized basic structure by bringing in Article 359(1), because it said that even during emergency, Article 20 and Article 21 cannot be suspended. So that amendment that was brought in through the 44th Amendment actually recognized the basic structure doctrine, none other than the very Parliament itself. So therefore, that assurance was given by the Parliament. Then, as you all know, the Indra Sani case, 1992, then S.R. Bommai case, 1994, then Nagaraj case, 2006, then the 85th Amendment, the famous Article 16(4)A, 16(4)B, that judgment, that's the 85th Amendment in 2006. Then, as you all know, the NJAC case, which is the 99th Amendment. So all these were cases where the basic structure doctrine was put to use by the court at a very, very crucial time in order to lay down what are all those fundamental things which has to be there if it has to be considered as a constitution at all. And here, one thing which I want to say is that Sirvai, who was against this basic structure doctrine to start with, and in fact, he was one of the counsel who was arguing, he completely came this side after the 39th Amendment. And in fact, he commented that the 42nd Amendment is outrageous. That's the word that he uses in his article. And in fact, his article is very, very, it's not his article, it's in his next edition. He talks about why people are dabbling with this term basic structure. So where he refers to the article where it talks about certain terms like negligence, reasonableness, natural justice. He says that these are all terms which cannot be defined with precision, but it plays a very important part in law and everybody knows what it is. So therefore, he says that it is not necessary that every time you want one word to be precisely defined and then only understand it, for which he gives certain terms which we are using on a daily basis, which you can never define perfectly. So that's something which I wanted to say. And if you look at the first time this till the 17th Amendment or so, it was all with land reforms laws. But for the first time, it was used, the basic structure of doctrine was used for something away from land reforms law, which is the Indira Gandhi case. And I must also tell here that a clumsy attempt was made to somehow review the basic structure, and the bench was the bench sat, and fortunately again one person from Madras High Court, whose name is Mr. Govind Swaminathan, who was the Advocate General of the Madras High Court, because suddenly the Chief Justice said review was requested by Madras High Court. So he jumped up and said that we never asked for a review. In fact, we completely accept the basic structure doctrine. Then he said, no, Gujarat High Court asked. Then the Gujarat High Court Advocate General stood up and said, we never asked for any. And so Chief Justice realized that it was going out of control. It was all dissolved. So that was one clumsy attempt that was made. I would say that two attempts were made. One is this clumsy attempt. Other is the 42nd Amendment. The 42nd Amendment was yet another attempt that was made. The last thing is it a judicial overreach? Does it require a revisit? Is the last thing which I wanted to deal with. More than 100 amendments have taken place in the Constitution. And we would see that this basic structure doctrine has been used only in very few cases where it touches upon the basic rights provided under the Constitution and where it deals with certain rights which cannot be bartered at any point of time. So the major policy decisions taken, the major implementation of development schemes by the government, at no point of time this basic structure has really intervened and struck down any of those things. And one thing we must keep in mind is that the basic structure doctrine which was derived by the Supreme Court will never collapse or undo a democracy. And the real threat is the unchecked legislature and executive who can really cause that disaster. So it's the basic structure will never cause such a disaster here. And two things you have to keep in your mind is that what happens when power gets into the brain. There was one attempt made, which is the proposed 41st Amendment bill. I don't know how many would have read it. Many would know about it. What do you know what that bill was? That bill was, it gave lifetime immunity from civil and criminal proceedings for a president, vice president, prime minister, and a governor. So no civil, no criminal proceedings. So a person can hold the post of a governor for one day. He can commit a murder. And then he will be completely exonerated from it. That's the extent to which power can really confuse people. So and fortunately for us, this amendment did not see the light of the day. So this was one attempt which is a very extreme case. And this basic structure doctrine has now been an inspiration for nearly 11 countries. 11 countries have taken it from us, and they have taken it to be a part of their law, and they are following it. And I don't find an alternative theory till today, which is not even suggested, which can replace this basic structure doctrine. Before concluding, I would remind a very recent attempt that was made in Israel. All this could have happened in India. So just listen to what I'm going to say. What they did was, it said that a law can be struck down only by the Supreme Court. And it said, when striking it down, at least 13 out of the 15 judges must be in majority. So out of 15 judges, it must be struck down unanimously by 13 judges. And what they said next was the insult to the injury. What they said next was, thereafter, if the same law is reenacted in the parliament, it will stand out, it cannot be questioned. So this is what, and this is something which was perfectly possible even in Indian scenario at that point of time. So if the Supreme Court had not come out with the basic structure doctrine, such insane amendments could have formed part of the constitution, and virtually the constitution would have turned topsy-turvy. Therefore, in my very humble view, there is no question of revisiting this doctrine. Thank you.
Thank you. Thank you very much, sir. It was not only illuminating, but also very, very entertaining and interesting. Whatever happens in different parts of the world has got a repercussion in other parts of the world as far as judiciary is concerned. Very true, sir. Now, may I request Justice Gopinath, sir, over to you.
Being the second speaker after Justice Anand Venkatesh, I am put in a very difficult situation because whatever has to be said has already been said. In his very short, brief address, he has covered the entire gamut of the law, right from the first judgment to the last. But I thought that after hearing him speak, before that, let me thank the organizers for giving me this opportunity. I thank my esteemed brothers, Justice Anand Venkatesh and Justice Rajive Bhalla, and my brother from Andhra Pradesh for being part of this. Thank you very much. I think that I will start off from the fourth point that Justice Anand Venkatesh has mentioned, the basis, the jurisprudential basis for having a doctrine of basic structure. I think that the answer to that question would lie in the fact that we are now faced with a situation where we have various authorities, constitutional authorities, questioning the jurisdiction of the Supreme Court, suggesting the supremacy of Parliament. And therefore, people are in a state of confusion as to what is the role being played by the judiciary. Are they overstepping their limits? Are they issuing directions in cases where they have no jurisdiction to do so? All these are questions which are now being discussed widely. I even saw a post which said that since the judges are appointed by the president, in the name of the president, they have no authority. They have no jurisdiction to issue a direction to the president. I think that the answer to all these questions, including the doctrine of basic structure, lies in recognizing the fact that in our country, the sovereignty lies in the constitution and not in any institution, including the judiciary. Sovereignty lies in the constitution, and therefore, I think the jurisprudential basis for the doctrine of basic structure would lie in recognizing the fact that the constitution is supreme. And as Justice Anand Venkatesh put it, each branch of government, each branch of the state are only agents under the constitution, expected to play its role as and when they are called upon to do so. And the judiciary only interprets the constitution, only issues directions to ensure that the constitution is not violated in any manner. And this recognition of the constitution as the document in which the sovereignty in our country lies, I think forms the basis for the principle of basic structure. Now, as Justice Anand Venkatesh had already explained, the first spark of the basic structure doctrine was again borrowed from the constitution, from the judgment of the Supreme Court of Pakistan. Thereafter, it was developed in Keshavananda Bharati to mean that the power of now Golaknath, I think Golaknath also went to the extent of saying that the power of amendment does not lie in Article 368, but in the residual power of legislation in List 1. Now, I was recently listening to a talk where the book launch of Justice Rohington Nariman on this principle of on this doctrine of judicial, I mean, basic structure. He's written a beautiful book. I've not been able to lay my hands on that book. I believe that it will come to the bookstores very shortly. He said that the reason for the amendment after Golaknath was the fact that the Golaknath tried to place the power of amendment in the residual power of legislation in the parliament and not in Article 368 itself. Now, after Golaknath, the judges in Keshavananda Bharati used the words implied limitation. This is again from the speech of Justice Rohington Nariman, where he says that the term implied limitation used in the judgments of 5 of the judges comprising the bench in Keshavananda Bharati should have been, actually they should have used the words inherent limitation instead of implied limitation, which would have been a more appropriate term according to Justice Rohington Nariman. Now, anyway, in Keshavananda Bharati, they went on to hold that the word amendment in Article 368 was a word used in a narrow sense. And kindly look at the law before Golaknath. This went to the extent of saying that Article 13 did not apply to constitutional amendments. Now, where did this take us? This took us to a very dangerous situation where every part, every article in the constitution could have been amended. And the Article 13 or any fundamental right, which could also have been amended, could not be put to test by courts by saying this violates any part of the constitution, any part of the part, any article contained in part 3. Now, this was the difficulty in as far as the law before Gopinath was concerned. Now, after Keshavananda Bharati, the judges, in fact, they accepted that there cannot be a repeal of the constitution itself under Article 368, which resulted in a situation where there must be something residual left back after exercising the power of amendment to its fullest extent. Now, this, I think, forms the basis for holding that there is something basic, there is something fundamental, which remains after the power of amendment would be exercised to its widest possible amplitude. And therefore, what remains in the constitution are those portions of the constitution which cannot be touched, which are so fundamental, which are so inherent to that constitution that it cannot be changed ever. Now, what could be the criticism of this doctrine of basic structure is the fact that it is fluid in one sense. As Justice Anand Venkatesh put it, there are portions of the judgment which indicate what the judges meant by basic structure. But even today, the position is that what is basic structure still lies in the hands of the judges to say. What constitutes basic structure? Should a challenge come before the court to a legislation or a constitutional amendment, alleging that it is on the ground that it is in violation of the basic structure? So one criticism of the basic structure doctrine could be that it is fluid in the sense that it is not a settled principle that these are the grounds upon which the courts could interfere with the legislation, a constitutional amendment, on grounds that it violates the basic structure of the constitution. So it leaves scope for the courts to actually expand the power of striking down law by holding a particular constitutional amendment or a legislation. Now, there are some discussions as to whether the principle of basic structure could be used to strike down ordinary legislation other than, or whether it is only in relation to the constituent power, the power to amend the constitution flowing from Article 368, or whether the principle of basic structure could be used to strike down ordinary legislation also. Now, I think the general view is that even ordinary legislation can be tested on the grounds of violation of basic structure. Let us take the case of L. Chandra Kumar, for example, which took away from the Administrative Tribunals Act, took away the power of judicial review under Article 226. Now, judicial review is found to be part of basic structure. So, ordinary legislation also, in my humble view, can be tested on the principle of basic structure, and we could strike down ordinary legislation also, and not just constitutional amendments by applying the principle of basic structure. Now, does the principle of basic structure make our constitution too rigid, in the sense that there are some parts of the constitution which cannot be touched, even if the need of the times is that it must be modified, it must be changed, it must be amended? Now, I believe that, as my brother Justice Anand Venkatesh put it, now we have no better theory, no better alternative, no better way in which we can ensure that the rights that were guaranteed to the citizens, we the people, and the framers of the constitution, we gave to ourselves this constitution. The only principle that we can apply to ensure that the fundamentals of the constitution, the fundamental basis of the constitution. Now, suppose an authoritarian government were to say that we would tomorrow have elections only once in 10 years. Should we not be in a position to say that no, elections every 5 years is also part of basic structure? Suppose they say 10, not 10 years, 15 years or 25 years. The present government will continue for 25 years by amending the provisions and saying that we will not have elections every 5 years. It will be only once in 25 years. That would be disastrous to democracy. That would be disastrous to the constitution and the principle of rule of law as we know it. And therefore, even the argument that this principle makes our constitution too rigid, incapable of amendment of its fundamental features, is too weak an argument to say that one must discard this principle of basic structure. Now, several attempts were made to undo the principle laid down in Keshavanda Bharati, followed thereafter in the judgments, including Minerva Mills, etc. After the Indira Gandhi case, now the amendments in Indira, which were subject matter of consideration in the Indira Gandhi case, those amendments were so drastic. It required, for people who have not read the text of the amendment, it basically said that the election of the Prime Minister and the Speaker would not be decided on the basis of any law that had been applicable prior to the amendment. And every appeal, whatever it was there before the Supreme Court, will be decided on that basis. So all the judges, including the judges who were in minority in Keshavanda Bharati, actually applied Keshavanda Bharati, principle in Keshavanda Bharati, and came to the conclusion that those amendments had to be struck down. Now, then came, as Justice Anand Venkatesh said, then came the attempt to constitute another 13-judge bench to reconsider the judgment in Keshavanda Bharati by Chief Justice Ray. And as my brother put it, the Advocate General of Madras, first, it was pointed out that Mr. Falkiwala's client had actually wanted a review of the judgment in Keshavanda Bharati. Apparently, reportedly, just Mr. Falkiwala stood up, who was present in court. He stood up and said, "Why would I seek review of a judgment where I have argued and established a principle that has been accepted by the court, by the majority?" Then the statement was the state of Tamil Nadu had wanted a review of this judgment. Then Mr. Govind Swaminathan, Advocate General, who was present, said, "No, we have not asked for any review. We are standing by basic structure principle laid down in Keshavanda Bharati." Then the learned Chief Justice turned and said that Gujarat has asked for it. The Advocate General of Gujarat also said, "No, we have not asked for review of this judgment in Keshavanda Bharati." And apparently, going by what was discussed in the book release function of Justice Rohington Nariman's book on basic structure, there was a revolt in chambers. Hello. And resulting in a situation where the Chief Justice had to come and announce that the bench had been disbanded. And then came, of course, the 42nd Amendment, which introduced those sub-articles into Article 368 and the judgment in Minerva Mills. So we are while I mean, I personally, I would think that while there are various discussions on the presently in the context of the NJSC judgment and the manner in which judges should be appointed or how judges should be selected, appointed, etc., etc., etc. As my brother put it, unless we have a better theory, a better principle than basic structure to protect our constitution, to uphold the values of the constitution, and to ensure that the basic features of the constitution are not meddled with by an authoritarian government, we have to apply this principle. We have to ensure that this principle goes on, though it is not something that is found in the text of the constitution. Now, coming back to the to what I said in the beginning of my short statement on this principle, or whatever I know of this principle, if one recognizes the fact that the constitution is sovereign, the fact that the text of the constitution did not refer to a principle like basic structure, Article 368 did not specifically state that certain parts of the constitution cannot be amended. As an agent of the constitution, the courts have and should have declared that the principle, that certain principles of the constitution, certain fundamental features of the constitution cannot be amended. And unless we have a better jurisprudential basis for saying that this basic structure doctrine should be replaced by a better doctrine, or a doctrine that moves with the times, I think we are stuck with the principle of basic structure, and we continue to be governed by the principle of basic structure. And therefore, I also agree with my brother Justice Anand Venkatesh in saying very affirmatively that the principle of basic structure is here to stay, and we should continue to apply it as long as we have no other principle that would be in position to replace that principle of basic structure. Thank you. I think the rest of the topic, I think I will leave for the other speakers to deal with. And as I said, after the illuminating speech by Justice Anand Venkatesh, there is nothing more that I can say about this. Thank you very much. Thank you.
Thank you, Justice Gopinath. It was indeed wonderful, thought-provoking, and emphatic. Now over to Justice Nyayapathi Vijay. Yes, Vijay.
Good evening.
Good evening.
It was a learning for me, basically, after hearing Shyam Padman speak so emphatically on all these subjects. And you have put me in a difficult spot to talk about these aspects, where he is so authoritatively has already spoken about. I will not take much of time. But what I have noticed when I was asked to speak is where is this basis? How did this principle?
There is a problem in the audio.
All right.
It's not very clear.
Yes.
Still audible?
Better.
Okay. I was wondering where this genesis of this principle, because of this principle. Then I came across one article which was published in Indian Law Review sometime in 2021, written by Monica Paulsen. It had taken this aspect of basic structure as to how it evolved. How it said that one person, German lawyer by name Dietrich Conrad, had written articles on this, which is referred to in the Keshavananda Bharati case also. What is the genesis of this Dietrich Conrad's philosophy of basic structure was very well articulated in that paper. She refers to two German and French constitutional lawyers by name Carl Schmitt and Maurice Harrow. And according to Carl Schmitt, I mean, this is the first of the principles, because there was a lot of churn, I believe, in Europe at that point of time as to what the identity and what is the limit of the amending power. According to Carl Schmitt, even the fundamental facets could be amended by a constituent power, that is the people or the monarch. But what are those fundamental facets of the constitution which should be amended by the people and which is to be amended by the elected body were not specified. This is one school of thought of Carl Schmitt. Then it was more like a, then there was this person, Maurice Harrow. He says, I'm cutting short this elaborate write-up which I have myself. He says that a special body should be elected specifically for the purpose of amending these fundamental facets. And only that elected body, which is akin to a constituent assembly, has the power to amend the fundamental facets of constitution. Now, this individual, Dietrich Conrad, formulates a theory saying, adopting Carl Schmitt's theory in part, because Carl Schmitt says the amendment could be done by the people, but this Dietrich Conrad restricts it to the idea that basic structure could not be amended. So this article of Dietrich Conrad was published in 1970, Limitations of Amendment Procedures in the Constituent Power, which was referred to in the Keshavananda Bharati case also. And this principle, so there was a lot of churn. In fact, there is a lot of literature on this particular aspect, where the French philosophers who had made certain ideology with regard to the power of this limitation of power. These were the basis as to how this principle eventually came. In fact, Dietrich Conrad gave lectures in Parthi in the university, also Banaras in the university. And this is the basis for this principle, which eventually was accepted by the Honorable Supreme Court. What I understand is that this improved version of this principle, which is the basic structure, which is an improved version, much improved than what was being discussed in by these legal peers of Carl Schmitt and Maurice Harrow, was adopted here. I think it is some sense of a, we need to recognize the greatness of our judges who wrote those judgments at that point of time, evolving this new principle. And this is all I would like to say, because this is the jurisprudential basis where this had evolved over a period of time. Of course, Carl Schmitt was also there. His deficiencies were led to his principle of people power led to the Hitler, rise of the Hitler and all. That is another part of the story. But we have adopted the better part of his philosophy in the basic structure. And the basic structure is more or less like an aura around the Indian Constitution, limiting the power of the makers of law. It is an invisible aura. But what is said in that particular article is that it should be a last resort to strike down an article. It's not something which you use at the first instance, not the thing that you use at the first instance. It should be the last weapon, last principle that should be utilized to examine whether this particular, whether a particular amendment crosses the basic structure or not. It has its own advantages. In the present day scenario, as Justice Anand Venkatesh said, we don't have any alternative at this point of time. And only time will tell, because law is always dynamic. Passage of time, we need to see whether this principle still holds good. I mean, not in the immediate future, but long after us. Thank you.
Very, very true indeed. Very true. Short, but on to the point. Thank you very much. And now, can we have Justice Rajive Bhalla, sir, please?
So you're on mute.
So you'll have to unmute. Yes.
Okay. I'm getting a little digital trouble.
It's perfectly okay now.
Okay.
Yeah.
Thank you. Good evening, everybody. And Actually, I mean, I think most of what I had to say has already been said. And like the two before me uh, said that there's nothing much to say. But what I would say is we've traveled a distance since the judgment in Keshav Nand Bharti. We are now again faced with a particular challenge where every government, and I'm not saying any particular government or any government, will make an attempt to somehow alter not only this doctrine but also alter the basic structure of the constitution. As I read the program for today, my thought was not what is the basic structure or how it came about or how uh, eventually it was saved in the constitution, but my thoughts were with the 13 gentlemen who were in courtroom number 1. And what did they think when by a whisker of 1 or maybe point so and so the question of doctrine, the doctrine of uh, basic structure sailed through. Now, when it sailed through, if I recall, I was a young person then, maybe in college and not even in law colleges yet. There was a lot of hue and cry, very, very similar to what the hue and cry being raised today. Very similar comments being made, very incendiary remarks being made. I won't say against the bench, against the judicial system. So we are now in part, let me say, 3. Part 2 when the attempt was made to again nullify it. We are now in the stage of part 3. I'm sorry, I don't intend to be political, but then the topic has a little nuance. If you see the topic, it has a little nuance in it. And how I read it is, how are we going to protect this? Everybody understands basic structure, and uh, Justice Gopinath, Justice Anand, Venkatesh, and everybody else has taken us through this, and we've understood how it came about, how it is there. But the question is there a need to protect it? And should we protect it? And if so, how? But before I take this a little forward, there is something which I just read today. In fact, just 5 minutes before I started, there was a conference in Gujarat today where Justice Suryakant was heading it uh, as the legal service chairman of the Legal Service Authority, and I just quote his words, and I think that is the essence of not only the Constitution, but that is the essence of the basic structure also. I just quote those words. I'm sorry, I noted them down, and I'll just quote those words. Uh, the measure of a nation's justice is how many of its citizens never have to fear injustice. Sense of security felt for the poorest. I mean, well, I am a lawyer in the Supreme Court and probably have to appear before him on Tuesday or Wednesday. But still, I think something which I have to appreciate must be appreciated. The sense, I feel that's the essence of almost what we need to protect. I'm putting it in a different way. What we need to protect is the measure of a nation's justice is how many of its citizens never had to fear injustice. And with due respect to all of you, you're all lawyers, judges, everybody, the word injustice does not just mean that you get beaten up in a police station, does not even mean that you get hauled up by a police station on the side of the road. Injustice can be even to the smallest peon in the office whose service is terminated. It can even be to the poor woman on the road who is asked to stop vending her wares without having any wherewithal. So injustice has in the constitution, and which, in my thinking, is purely protected by the basic structure, and which is always under attack every 4 5 years. Every 4 5 years, somebody or the other from one party to the other gets up and starts a new theory of law, thinks he's invented the wheel for the first time, forgetting that there are lawyers like Justice Gopinath, there are judges like Justice Gopinath and Venkatesh who know this system backwards, who know these, who can easily tell you in a minute what is wrong with what. The question here is, now I'm just coming to, please, why I'm taking you through this little, maybe may sound a little political, but I am a purely apolitical person who is just, his only concept in life is that everybody should try and should get justice, and that's the job of a court. That's the job of a judge. A judge, with due respect, must of course read the preamble every day. If not every day, that's asking for too much, but at least once in a month, read the preamble, and then remember, it's the compassion of a judge that decides the case, not necessarily his legal acumen. And that is where the basic structure will protect not only the judge's thought process, but when you come to deprive people of their land, firstly by land reforms, you in Tamil Nadu and Kerala you had land reforms. In Punjab we had a much more serious implementation actually, where in fact the first judgments were from Punjab on all these laws. Not only that, even our common land, if you remember, which you give a different word to it, the common land of the panchayats were also taken away. Were also taken away by the government and vested in gram panchayats. All those, unfortunately, were upheld by the Supreme Court. They were upheld by the Supreme Court on, I would say, on a very on a suspicious doctrine. I'm sorry to use that word. That if the government is taking away your land, which is your land for common land, it's only going to be used by the panchayat for your good. The Supreme Court was not aware of the fact that all this land, the government will eventually sell it off to industry, sell it off to everybody. And the poor villager whose couch around it was, that's the word we use in the north, where his cattle had to be taken off, there's no land left. So we are faced with a crisis where I say this is one example of the Supreme Court itself not reading, this is before Keshav Bharti, into the judgment, the basic structure of the constitution. I'm not saying on the right to property, but on the right of a simple person in a village who has to graze his cattle, who has to look after his land. Those are common land. The Supreme Court, in fact, threw out the baby with the bath water and handed it over to gram panchayats. We all know what gram panchayats are in today's times. They are more monstrous than even our municipal committees. So sorry to use those words, but I've had a little experience. I know this. Now coming back to what is happening. If you may, I just rewind to the year 2023. You may all recall the same gentleman, this time with the law minister, attacked the Supreme Court from the floor of Parliament that it's the will of the people that will prevail and not the will of the Supreme Court. This is in 2023. And what his attack was on Keshav Bharti. That this doctrine of propounded in Keshav Bharti, the exact words of the gentleman are nowhere in the constitution. So you have imported into the constitution, and even somebody also said, though it was not so virulent at that time, you have imported it from Pakistan. So even somebody even commented that you don't even realize what you're importing from Pakistan into India. So this is how we are faced with it. Here we are now. All of you are lawyers. Well, you may disagree with me, you may agree with me, that's your right. And that's the right which is protected by the basic structure. If you disagree with me, please do. But please do not say that the judges don't have the power. The basic structure is all rubbish. The basic structure is imported from Pakistan. Some people just don't seem to understand that the common man begins to believe when a constitutional authority says something, they begin to believe the truth of that statement. And that statement is then twisted, turned. So that is what we need to protect from. And I think the job of lawyers, if you remember, lawyers were always at the forefront of everything, including the freedom movement, the emergency, the anti-Indira Gandhi, the JP movement. Every movement was fronted by lawyers. But unfortunately, lawyers have now become corporate entities. And they have more or less, it's only in this group that I get to see some sort of a socially relevant discussion. But most groups is always on arbitration, commercial this thing, so and so. So we are fine. It's good to make money. All lawyers must make money. Everybody makes money. But please, some compassion, and do not abuse this basic structure. And when this gentleman made that statement which I'm referring to, I do not claim to be any expert on the Constitution. I do not claim to have any great knowledge on the Constitution. So I rang up some of my eminent friends who were on the Constitution side, and they all had a nice laugh. They said, "You have nothing better to do but to ask us to comment on this." I said, "Well, you see, he's such an eminent person, supposed to be an eminent lawyer." So that is the level I'm saying. That is what we have to protect from. Now the latest attack. I'm sorry, there are a few sitting judges here, but I hope I don't embarrass them for that. There is uh, the latest attack. Now, I hope everybody's read that judgment. It comes from your part of the country. I don't think there's even a word out of place in that judgment. Can you have the president sitting over any legislation for years and years? Can you have the governor sitting over legislation for years and years? When the Supreme Court, the High Courts, even the magistrate says, please decide everything within a particular period of time. Reasonable time. Reasonable time is defined. So what we are facing right now is a backdoor entry into trying to, I would not say nullify. I think we are all strong enough to withstand all that. But at least to push the door and make an entry despite the repeated upholding of the doctrine of separation of powers, basic structure, rights of man. All these things are now well established. And now, over the last how many years? 73, the judgment came. We celebrated, I think, 50 years also. And we are still arguing about it. That's what mystifies me. We are still arguing about it. After 50 years, we are still saying, is it right? Is it wrong? It should not be like this. It should not like this. Supreme Court may not have opined on it again and again, but that's what I exactly. Now, can I just a small little maybe another this thing? Would Parliament be able to abolish Parliament? Where would that come? Basic structure. Would the President and the Prime Minister rule by decree? Where would it come from? Would they abolish judicial review? They did attempt on small parts of it. Can they abolish fundamental rights? They can modify them. They can amend them, but they can't abolish them. Can they impose a presidential form of government? And most important of all, because I'm speaking to people who are from the South, abolish the federal structure. Can they do that in view of this doctrine? So this is where we need to protect everything. So with the least amount of legal acumen at my command, and thanking everybody else for having made me wiser on all the judgments I've noted, all of them made the points. I'm probably speaking at some other college next week. So I'll hand over all those judgments to them. And thank you very much. And I won't take too much time. Actually, I was just 15 minutes before this, I had some a stomach issue, but I joined because I promised. So thank you very much, Padam and Premraj and everybody else. Thank you for being kind enough to listen to my incendiary remarks on everything. But then that's the way I am. And that's the way I hope you always look after me like that. That's all. Thank you very much.
Thank you. Thank you very much, sir. It was, the problem with your stomach did give impetus to the way in which you spoke. So it was really good. It inured to the benefit. We have Justice Ramesh sir here. Can we have a comment from?
I saw him there, sir.
Sir, please, can you unmute?
Sir, can I, please, everybody, can I just leave, sir?
Yes, sir, please. I mean, the precarious position you are in, we understand and appreciate, sir.
I had something which I normally don't eat.
Temptation always make you.
Yes, that is true. All right, sir. So just
Okay,
like
thank you. Thank you very much, sir.
temptation to change the basic structure is every political dharma. That is their dharma. Okay, sir. Bye. See you.
Yes.
Okay,
Thank you. Thank you.
Ramesh sir.
Thank you very much, Shyam. I really heard just 3 judges, sitting judges, and one a former judge, now a practicing lawyer. So there is a different views. But ultimately, though it was 50 years over, more than 50 years over of the basic structure, still we are wandering in a place where what is basic structure, where whether the basic structure doctrine can survive or not to survive, etc. But ultimately, courts have held there must be something required for the purpose of check the unbridled power of the constitution to amend the constitution, which is likely to affect the basic rights of the persons which have been enshrined in the constitution by the constitution makers at that time. Because all the judgments it has said, Article 368 gives a power for the legislature to amend. But the question was, to what extent the power of amendment can be exercised by them? At that time, for the first time, in Kesavananda Bharati's case came the question of basic structure doctrine. They did not say what is the basic structure. But ultimately, when you read all the judgments, we can understand that if it goes to the root of the constitution itself, it is likely to affect the rights that have been given under the constitution. And if it is of draconian nature, it is likely to affect the democracy which was intended to be protected by the constitution itself. Then it will have to be viewed by the court. And then the basic structure doctrine will be applied to see whether how far they can balance the amendment with the situation. They did not say that it always basic structure will come to the aid. But they will have to strike a balance between these two, how far they can able to protect the constitution itself, either by allowing the amendment or not by allowing the amendment. Even in the Subramania Bharati's case, the Subramania Swami's case came, the question as to whether the power to grant sanction can be kept with the state or the authorities for a longer period. And they came to the conclusion that there must be a reasonable time in which it will be done, or it will be presumed that the sanction has been granted. They did not say the sanction has not been granted, the sanction has been granted. The same has been incorporated in the present CRPC, because as Anand Venkatesh said, it is very difficult to name the present law. But however, the present the CRPC, it has been incorporated, so some power, but some restrictions have been given that you will have to decide in a particular way, particular time. So this is the area where, when there is no time limit provided under the constitution to exercise the powers of the constitutional authorities, can the court go into the question and fix the time? That is the area where now the controversy came as to whether court has got the power to do or not. That is the reason the judicial review comes. When the judicial review was taken out in some of the constitution, some of the enactments, Supreme Court has said, no, you should not take away the judicial review, because the judicial review is a power given under the constitution where certain things will have to be looked into with the constitutional courts alone. And that right cannot be taken away. But unfortunately, how far that Chandrasekhar's case has been utilized by the constitutional courts for the purpose of exercising their power of judicial review is always a question mark even now. When the statute says that you will have to do it in a particular way, and certain provisions have been provided in the constitution, so the act itself as to how this will not be challenged. Can the High Court using Article 226 and 227 get into those issues and do it? Because even in the Chandrasekhar's case, it was clearly mentioned judicial review is restricted to certain aspects alone. Only if those things are violated, the power under Article 226 can be exercised by the constitutional courts to set right that portion and send it back, because they cannot decide the issue again. They can only send it back to the court or the institution which decided it in a wrong way or otherwise. Basically, it goes to the perverse or against the provisions of the law or the violation of principles of natural justice. But now it has become a first appellate court. And the decision is being either allowed or disallowed. That is the way in which the interpretation of the Chandrasekhar case has been taken by the constitutional courts now. Very sorry to Anand, Venkatesh and Vijay. Personally, you may agree with me also sometimes. Because courts are not powerless. That is one we will have to think about. When the situation is not provided, you will have to find out a method by which the constitutional rights will have to be protected. Their rights, as Anand Venkatesh has rightly said, when there is no provision in the constitution as to what is the basic structure, how this will have to be interpreted in a particular way as to provide an amendment to be accepted or not to be accepted. Till then, the basic structure principle will have to be upheld. Otherwise, the difficulty will be, as rightly pointed out by Rajive, a legislation may come tomorrow, taking away right to vote also, because they may decide whether a particular type of persons can vote or not to vote. Can it be said that it is within the power of the legislature to amend a particular provision and then do it? I don't think it is possible, because it is a right given to the people. We the people of India, by the constitution, to elect those persons to decide our fate. I can only say decide our fate. Whether they are properly deciding it or not, who will oversight it? Only the judiciary can do it, because judiciary is supposed to be the watchdog of the protection of the constitution. That is the reason why the advisory jurisdiction is also given to the Supreme Court. Even if the law has been passed, if it is sent to the assent of the president, if the president has got any doubt, he can refer the matter to the Supreme Court for get the opinion of the Supreme Court as to whether what is to be done. So the constitution maker is very, very sure about the possibility of misusing the powers that has been given to the legislature. So somebody must be there to protect it. So that can be possible only by the judiciary alone. So if you take it in that way, the basic structure doctrine will have to continue. And that is my view. Thank you.
Thank you very much,
Now,
sir.
only
From
2-3 things I wanted to just clarify, if you
Please,
permit me. Can I?
please, sir, please go ahead.
See, basically, even in Kesavananda Bharati judgment itself, Justice Ray uses the word basic structure is an exercise in imponderables, being vague. That's the word he uses. As you know, Justice Matthew was a dissenting judgment there. But it's very interesting that Matthew at page number 826, he says, he actually entered a caveat and he says that merely because it may be difficult to ascertain an essential feature doesn't mean that it doesn't exist. And it's a very, very important expression used by a judge who dissented in that judgment. So that's what Matthew says. And to understand its scope, as I told you earlier, the one which was written by Sirwai, where he refers to Lord Reed, where I said that there are many expressions which we use for which we don't have an exact explanation, like the negligence, etc., which I said. So that's one thing which I wanted to say. Second is the one which was referred by Justice Gopinath about whether this basic structure doctrine can be applied beyond constitutional amendments. As I could read it, this is my opinion about it. As I could read from all judgments, what I find is the doctrine directly tests constitutional amendments, but laws dependent on see, basically, the doctrine directly tests the constitutional amendments and also the laws which are dependent on such amendments and which are indirectly affected. These are the laws which can also be tested with this. But then it is an indirect test. It is not directly tested under the anvil of a basic structure. As you can see, the Vaman Rao case, 1981 Supreme Court. In Vaman Rao case, you will find this is a post case of Anand. It tested the laws that were added into the 9th schedule. And Koil Ho case, which Premraj said, they said that from the date on which the basic structure doctrine came, even those laws which have gone into 9th schedule can be tested now. So so what I feel is ordinary laws remains a subject to fundamental review alone, and it's not tested under the anvil of basic structure unless the parliament uses such amendments to shield them from unconstitutionality. That's my opinion about it. Then this majoritarianism about which Justice Bhalla said, you will find that Khanna has addressed this at paragraph number 1418 of the Kesavananda Bharati case. He debunks this. He says that what majority are you talking about? What majoritarianism you are talking about? He said that constitution is focusing, giving rights to minorities here. So it's the last person whose right is involved here, which cannot be defeated by persons who call themselves as majority. This has a lot of significance, and this becomes an issue wherever a majoritarian government assumes power in the center. It can be the A party, it can be the B party. But then this majoritarianism, the will of the people having elected us, etc., comes where a majority government sits. And this is debunked by Khanna in the very judgment itself, where if you can read para 1418, you will find that. And lastly, I read preamble on a daily basis. The preamble of the Constitution, wherever I go and speak with students, where I go and speak with advocates, I make all of them stand up and recite the preamble of the Constitution. When you recite the preamble of a Constitution, that gives you that energy. That many say that preamble does not form part of the Constitution. No, I think Constitution is walking behind the preamble. Preamble is leading the Constitution along with it. So Khanna would say that it's a wrong understanding to say that it does not belong to the preamble. Preamble is the one behind which the Constitution walks. So actually, in order to draw inspiration, whenever I feel dull, whenever I feel depressed, I just go through the preamble and start reciting it loud, like some prayer. Thank you.
Thank you.
Just one word, Shyam.
Please.
See, this principle that ordinary law can be tested again on the principle of basic structure. I think if you recognize that the Constitution, just like in Kelson's pure theory, that Constitution is the grand norm and everything must answer. Subordinate legislation to plenary legislation, plenary legislation to the Constitution, Constitution to the fundamental rights. If you look at it that way, even without possibly applying any doctrine of basic structure, an ordinary law could be tested on the ground that it violates the Constitution.
Right.
Without actually going to the extent of saying that it is on the principle that it violates basic structure. If it violates any provision of the Constitution itself can be saved, essential features saved by applying the principle of basic structure. Ordinary law, by applying the principle that it can't run against the principles enshrined in the Constitution.
Very true.
Can I make just one
I think, Prem.
See, with the greatest respect, in relation to this observation concerning striking down an ordinary legislation on the ground of violation of basic structure doctrine. Now, the first case was Indira Gandhi versus Rajna Rai, 75 Supreme Court. They directly held that the constitutional validity of the statute cannot be challenged for violation of basic structure. Of course, Chief Justice Beg, he dissented. Then second was a 7-judge bench decision, that the state of Karnataka was Union of India. So 1977 4 CC 608 with Justice Undwalia speaking for the majority. He reiterates this position. Validity of the statute, you cannot test for the violation of basic structure of the constitution. For the basic structure. This has been recently approved by Justice Chandrachud Nanjum Kadre, I don't remember the citation, it's a, I think 2023 or 2024 judgment, where Justice Chandrachud would say that permitting courts to strike down the legislation for violation of such a concept that may introduce some sort of uncertainty in our constitutional adjudication. Now, this is what Justice Chandrachud observed. Now, this is my understanding and I'm subject to correction. And of course, if it violates the constitution, of course, true, it has to go. But on the principle of basic structure anyway.
Very true.
That's it.
And from the words of the eminent speakers, I could put it into under 5 categories, the criticisms. Number 1 is vagueness of the basic structure doctrine. No clear or exhaustive definition provided, leaves judges with broad discretion to interpret what constitutes the basic structure and criticized as being uncertain and subjective. Then second one is judicial overreach. Doctrine gives unelected judges the power to invalidate constitutional amendments, seen as undermining parliamentary democracy and upsetting the balance of powers. The Supreme Court overstepped by introducing the basic structure doctrine, limiting Parliament's power. Then as judicial overreach. The third one, which could be identified, was inconsistency in judgment. Delivered by a 13-judge bench with 11 separate opinions, difficult to extract a single binding ratio. The ruling is notoriously complex and confusing. Then comes limits constitutional amendability, restricts Parliament's power to amend the Constitution under Article 368. Critics also argue that Constitution makes the Constitution rigid and less adaptable to evolving needs. Then, like everybody said, no textual basis. The term basic structure does not appear anywhere in the Constitution, considered by some scholars as judicially created doctrine with no express constitutional sanction. And finally, it is criticized as having some sort of erosion of parliamentary sovereignty. Seen as a departure from the Westminster model, where Parliament is supreme, critics argue it shifts sovereignty from the people's representatives to the judiciary. Impact on federalism. Others debate whether the ruling strengthened or weakened federalism in India. While Keshavananda Bharati is hailed as a bulwark against authoritarianism, it is also critiqued for judicial activism, conceptual vagueness, and weakening democratic process. To render the concluding remarks, I just put it in a short form. I'll just have it, and then the magic word of over to Prem will follow. 50 years on, the basic structure doctrine endures not merely as a judicial safeguard, but as a quiet moral compass within our constitutional architecture. It reminds us that while constitutions may be amended, their essence must be preserved, that power must be exercised within bounds, and that the rule of law must remain anchored in justice, not just legality. As we commemorate Keshavananda Bharati, we do not merely revisit a judgment, we reaffirm a jurisprudential legacy that entrusts the court with the solemn duty of preserving the Constitution's identity, and with it, the democratic soul of the Republic. In a time of shifting majorities and constitutional trusts, the silent sentinel continues to stand, vigilant, principled, and profoundly necessary. The deliberations today reflected the profound legacy of the Keshavananda Bharati judgment, with our distinguished speakers offering rich perspectives on its enduring relevance. From reflections on the doctrine as a bulwark against majoritarian overreach to nuanced discussions on its philosophical underpinnings and comparative constitutional dimensions, each address reaffirmed the doctrine's role as the invisible thread binding constitutional continuity with democratic vitality. The speakers unanimously underscored that the basic structure doctrine is not an impediment to change, but a safeguard of the Constitution's moral and structural coherence, a testament to the judiciary's role as the conscience keeper of the Republic. As we mark another year since that seminal pronouncement, today's conversations serve as a reminder that the Constitution lives not merely in its words, but in the values we protect, interpret, and uphold with vigilance and fidelity. Thank you. Over to you, Prem.
May I please, sir?
Yeah, please.
Now, Justice Gopinath sir and all other speakers at some point of time have mentioned that the basic structure was borrowed from Pakistan initially and applied to Keshavananda Bharati. Now, my question is, whether this Keswananda Bharati judgment had any global impact anywhere in the world in any other country. My second question is, can an ordinary legislation be struck down for violating the basic structure of the constitution? These are two of my doubts. Parliament passes a bill and it becomes an act,
we
and
got the
later we
question.
come to know that act becomes against the basic structure. Will
Yeah, we got the
that,
question.
will
Yeah,
that be
please.
struck down?
Would Prem or Justice Anand
First,
Venkatesh sir would.
the first question is, Kesavananda Bharati never borrowed it from Pakistan High Court. The reference to the Pakistan Chief Justice was done by Mudolkar in Sajan Singh case. That's all. Mudolkar had made a reference to that. In fact, what was present in the hands of Mr. Palkiwala was this article written by this German thinker. So therefore, it may not be right to say that the Dieter Cornard's exposition on this. So that was the only piece of paper that was available, and that was developed by Mr. Palkiwala and others during the course of their arguments. The reference to Pakistan is only a reference that was made by Mudolkar in Sajan Singh, where he took a cue from there. And it was not the original message that was conveyed by the Chief Justice of Pakistan, because it already had a basis to it for quite a long time even before that. There was a lot of speech, there was a lot of material available on these basic features. So that is number one. Number two is, again, going back to this question as to whether the basic structure doctrine can be used to strike down ordinary laws. I think myself and Justice Gopinath made it clear that the doctrine of basic structure, as we understand, is only to test the constitutional amendments. And there are some laws which are dependent on such constitutional amendments, which can also be indirectly knocked off by using the basic structure doctrine. But per se, you will not be able to utilize this basic structure doctrine to knock off a ordinary law. An ordinary law will always be tested in the anvil of the provisions of the constitution, like beyond the power of the legislature or violating part 3 of the constitution, etc., etc. So as such, if indirectly that ordinary law is connected, like the one in the 9th schedule, let us take for instance, one in the 9th schedule, that can be tested in the anvil of basic structure doctrine. So it has to be, it is done indirectly. It will be connected to a constitutional amendment, and it is better that basic structure doctrine is used only for testing constitutional amendments, because if it is used for all and sundry, it will be watered down. The criticism will become more.
Correct. Thank you, sir.
Shyam,
Alex,
can
you
I
wanted
add
to
a
add
word?
something?
Thank
Yeah, please,
you,
Alex.
sir.
Yeah, please. Alex,
Oh,
please.
sorry. KK Matthew, he said, just because we cannot define it accurately does not mean it does not exist. Something similar happened in US Supreme Court. One justice named Potter Stewart, talking on the subject of pornography, says, I cannot define it, but I can recognize it when I see it. That's what he said. Also, there is an example in fiction where the basic structure completely brings chaos. In George Orwell's Animal Farm, they've got a written constitution called the 7 Commandments. And one of the commandments is no animal shall drink alcohol. So they make a little amendment, no animal shall drink alcohol to excess. That is okay. Slowly they amend it, and finally the entire constitution is changed, and they say all animals, it's all completely rubbed out, and they say all animals are equal, but some animals are more equal than others.
More equal. Very true.
Anyway, we are going through in America a very dangerous situation, much more dangerous than in India, where the executive is in the hands of a complete mad person, and the judiciary is completely powerless, completely abdicated. That is sad. That is very dangerous for the America and for the whole world.
One thought, I think, for food for thought. Now, we have a written constitution. The United Kingdom has an unwritten constitution, but they go by convention. Now, what is this convention ultimately? Is it not basic structure? Now, if you have a written constitution, you say that you have the certain parts of it are basic structure. Now, if you say that a country governed by an unwritten constitution also is governed on the basis of certain conventions which have been followed.
Correct.
Correct. I mean, is it not still a principle akin to basic structure? Even an unwritten constitution, therefore, in one way, is governed by principle of basic structure. You have, I mean, elections every 5 years. You have, governments changing, enjoying, no confidence motion, etc., whatever it is.
Correct.
In fact, Carnot's the article of Carnot, it talks about 4 very extreme cases which has not happened in India. First case, he says, could India be divided into only 2 states, Hindustan and Tamil Nadu? I don't know why he used that. That's the first extreme case, he says. Could India be divided into only 2 states, Hindustan and Tamil Nadu? Then second, he says, could Article 21 be abolished? Then third, he says, could the amending power be handed over to the president acting on the advice of the prime minister? The last one was the most extreme. Could the constitution be abolished and Mughal or British rule be reintroduced? He gives these extremes and we have not reached these extremes. But he says, if power gets into the head, you will do anything. Like what I said when they attempted to introduce 41.
Correct.
Very true.
And
thank you.
word,
And Prem, just before that, may I just thank Nabe Usman for making that wonderful flyer of today's program, because that he was instrumental. And I think he's here. Yeah, thank you, Nabe, very much.
My pleasure, sir. My pleasure.
Over to you, Prem.
Well, just to answer Mr. Nawaz Jan's question regarding whether Keshavanda Bharati had a global impact, as Justice Anand Venkatesh has already put in, 11 countries. Now we need to be so proud, because the basic structure doctrine that was adopted in 1989 by the Supreme Court of Bangladesh. Then you have 2008 Supreme Court of Belize, 2009 by the Supreme Court of Uganda. Then 2015, the historic 17 judges bench, the highest in number, of the Pakistan Supreme Court in District Bar Association versus Federation of Pakistan. Then Kenya, almost like 11 nations have accepted that. And finally, I have to say that we do extend our heartfelt gratitude to the 4 distinguished speakers for their illuminating insights, for their very thoughtful perspectives and the generous sharing of knowledge, and their contributions that have truly enriched this session and left us with much to reflect upon. Thank you so much.
Thank you very much. Till we meet again next time.
Thank you. Thank you so much. Thank you to all. Thank you.
Thank you, everyone. Thank you so much.
Thank you.